So welcome everyone to the Sierra Symposium. This is the Student Practitioner Roundtable. For those of you not familiar with the format, it's not a panel. It is more of a discussion for students to connect with practitioners to go back here. The Sierra student days. But think of this as more of a workspace than
And for those of us who were here yesterday, we heard a lot from social psychologists, social scientists about colorblindness, its implications, multiculturalism, its implications, or that term, diversity, et cetera, sort of a race-conscious frame. And I think this is an interesting opportunity for us to share our experiences around those sorts of ideologies and those sorts of concepts. So while we're doing the introductions, we definitely want to be brief because we want to begin to get into the discussion. And also we want to adhere to the idea that blessed are the brief because they will be invited back. So keep it moving. So we have sort of three areas that we want to focus on for our discussion. We're going to be talking about sort of the culture of legal practice and the legal environment. We're going to be talking about our educational institutions. How is the culture in places like UCLA in sort of post-affirmative action environments as contrasted to those of us who may have experience in environments that are currently under or allowed to participate in race-conscious sort of means in terms of admission, and what does that do to the environment? Does it change it at all? And thirdly, we want to talk about the practice of law, the workplace. How do we experience that? How are those spaces, those colorblind spaces, how do we navigate within them? So with that sort of broad framework in the sort of participatory type of environment we want to facilitate, we have a couple of point people that are going to talk a little bit, but by no means are they the folks that, are going to sort of define the universe of what's to be said about a particular topic. So we hope that everyone will contribute to the conversation. This is really one of the few spaces during the symposium where we can really have an interactive dialogue. So I hope that everyone will participate. So with that, let's just move on to sort of the first topic area, which is legal culture and practice. How does colorblindness pervade the legal culture and the sort of practice that we're all either studying or participating in some way? So we have two folks that are going to talk about that. We have Chris Prince and Angela Chung. So if you want to share some of your thoughts about legal culture, legal environment, why don't we start with Angela since she's drinking coffee.
Well, I may need a lot more. So just in terms of just law school or just legal spaces in general?
Legal spaces in general.
Okay. So just a little bit in terms of my background. So I'm right now at the Los Angeles County Public Defender's Office. So that's a government agency. Throughout my 10 years, I was with nonprofit grassroots organizations. So just very overtly anti-racist organizations, some in Oakland. And so I was used to more nonprofit spaces. And then obviously I went to college, and that there's that culture there. And then law school, and then a county job. So I think just remembering like the type of institution you're at, that has an impact on the way in which race is going to play itself out. And let me know if you can direct me if I'm not being specific. So just, and I think in a county job, even though it is the public defender's office and it draws a certain level of sort of broad, like-minded people who have challenges to the criminal system, they think it's unfair, do they think it's racist, then you got a few prison abolitionists, there's a whole range of people. But it's not an overtly political organization in the sense that they have one unified political agenda or mission that they're doing. It's a service, it's a job, you're working with a certain clientele and population, and depending on the lawyer you get and their own personal or political philosophy and their life experiences, whoever they work with, it's going to be very, very, very specific. And so I would say, barring the county policies on don't sexually harass somebody, don't say a racist name to somebody at work, and their internal policies, I think generally barring those policies, there's an understanding like, yeah, it's a PC political space, you don't talk about it as much. You just, oh yeah, it's bad, yeah, there's racism in the system, sure. Yeah, and so where's your trial, So it's more about, I think, if you come in there with and I'm not going to assume everybody in here has the same sort of outlook on race. I don't know where everybody's coming from, but depending on that, the space is not a unified space. There's no sort of group collective understanding. It's very geared toward, yes, you're an attorney and you serve a certain clientele and population, and I think that was the challenge for me, because in a nonprofit organization that I was in, that it was very specifically anti-racist. It was about decriminalization of poverty in people of color communities. It was very clear in the sense of what that goal was about, and every strategy that you take was about that. And I think that's the difference with the county one. There's no collective strategy. Like if you're doing a trial, you're not doing a trial as, let's say, ACLU or even Center for Constitutional Rights would do a trial, right? It could be for impact litigation purposes, or it could be to prove a political point, or it could be to set precedent. But and there are people who want that in the county, but it's largely your tactics, your strategies, how you do your questioning, what cases you choose and why. It's really individual. It's really left up to the attorney within certain parameters. And I think, and even in your interactions with the client, as they like to call it, that is also, yeah, don't practice IAC, right? That's their standard, but there's no sort of training or perspective on in your interactions with your clients, the impact of race or racism on that. That's up to you if you have that level of analysis, or you have other colleagues who are there. So it's really up to you to sort of develop that space within the county. Am I going on and on? I mean, is there anything that you would like?
Angela, could you say what because some people might not know what IAC stands for?
IAC is Ineffective Assistance of Counsel. So a lot of times they'll be like, document your file, and they'll go through your file too to see if you documented it correctly, like, because you can get sued, and people do get sued all the time. Like a client tells you, no, I really, I didn't, the cop shot me in the back, like I swear I didn't, and then something happens and there's a lawsuit, somebody didn't believe, one attorney didn't believe their client or whatever, and then they can get sued. So they're always about like, document your file, write it all down that you said X, Y, and Z, but...
Right, so it sounds like, even though you're in a space where it's explicitly, it's clearly racial, and it's clearly racialized, the criminal justice system, there is an adoption of a colorblind sort of ethos within the organization, that there is no recognition of how race, or there's no training about how race functions within our criminal justice system. So not only are we responding to sort of a colorblind framework in terms of our case law, we are participating in reproducing that sort of colorblind ideology within the legal system. And maybe Chris Prince, you can introduce yourself and talk a little bit about, if you have any additional thoughts about sort of the legal culture and how colorblindness pervades that sort of art, the culture.
Yeah, I've been trying to think about what, I think I'm mainly here for comic relief, but trying to think about what useful I could contribute. Just by way of background, I'm a 95 grad, so I'm pre-CRS, pre-209. And it was a very different law school that I went to than the folks have been going to since 2009. And so and then my first couple of jobs after law school were kind of liberal do-gooder stuff. Worked for the NAACP Legal Defense Fund and the Natural Resources Defense Council. And then I was tired of being poor, so I went to work for McCutcheon, Doyle, Brown and Anderson. I may be the only person in the history of large firms that got a job out of a classified ad in the Daily Journal. But when I joined McCutcheon, I was the only black male in the LA office. I believe that remained true the 5 years I was there. I'm a partner at Sun and Shine, Nathan Rosenthal now. I'm the only black male in Sun and Shine. There was like a 3-month period before Percy got appointed to the bench, I think, that Percy Anderson was a partner there. Other than that, so my entire legal career, actually we didn't have any black males at LDF either, so my entire legal career, I have been the only black male in the office in which I worked. I'm the only black partner in California in our firm, I think. So it's not real colorblind in the sense of, you kind of notice stuff like that. So a couple of things strike me about the various spaces that I've been in terms of school and work and from observing. I was the president of Langston Bar Association, so I interacted, I think, with folks that worked in a lot of different environments. One is there's sort of the rules, and then there's the way things work. And the rules are basically generally ignored in terms of how things actually operate. And the way things actually operate tend to be grossly unfair, but they're sort of grossly unfair to everybody. And where I think some disparities grow up is that people of color, lesbian, gay, transgender, women, are less comfortable and less familiar with functioning with the way things work, and tend to try to operate with the rules. And it happens to everybody. I've seen white males get chewed up and spit out by the system also, but I think there's a slightly higher percentage of them who function better with the way things work. And just to give an example, we have a very complex and convoluted review system where associates are reviewed, they gather reviews from all the partners who they've worked with, it's discussed, it's hashed out by committee, it's shared with an associate. And if you might look at that system and say, okay, that's how I know how I'm performing, that's how I can be judged, that's how my career will advance. Well, it's completely irrelevant to your actual career advancement. The review process, the partners aren't honest. For a variety of reasons, there's a secret system in which partners share information about people that doesn't go into the review process. The people who actually participate in the review system are kind of irrelevant to your promotional prospects. And so if you focus on this colorblind, rule-driven process of reviews, you will go through your career at the firm, and I've seen this happen to many people of all races and genders. You'll go through your career and you'll get to the 5th or 6th year, and they'll say, it was really nice working with you. You're probably going to have to leave in a couple of years. And you'll say, well, what the heck happened? Because I was sort of watching the system, but the system is operating at a totally different level. And that level, I think, is both colorblind and very race conscious. We, as the handful of black partners in the firm, talk to each other very affirmatively, try and say, okay, this person, this black associate, we need to find some work for them or else they're going to be gone. And so it's colorblind at this sort of level of abstraction, but it's very, very race conscious. We in the firm, on committees, and in our discussions, are very, very conscious of it, and not many illusions.
So we want to kind of, at this point, I want to see if there are any comments on sort of the broad, this parameter before we move on, sort of the colorblindness as it functions within broadly within our legal culture before we sort of talk specifically about the educational environment and specifically the workplace. And I think a lot of what was said here will probably be talked about a little bit more later, but do the folks have any particular comments that they want to make about sort of the idea that institutions are reproducing colorblindness, whether it's, sort of our legal institutions, whether it's the educational environment or our workplace, before we move on. And again, these things will sort of lead into other parts of the discussion, but I want to kind of open it up at this point. Are there any comments or responses to what's been said earlier? Yes.
So I'm kind of wondering, often when we have this discussion, we have the pre-209, post-209 kind of division between understanding, a color-conscious world and then a post-racial or color-blind world. But in places like the Public Defender's Office or in firms, was there ever a moment where, particularly in the Public Defender's Office, where it was a color-conscious place, where there was a color-conscious ethos to somehow change over time to now a colorblind ethos? And if not, what are the prospects of bringing race in and trying to allow race to do some work in whatever sort of work that goes on, either in the firm or in the PD's office?
I mean, I've only been there for 2 years, but I don't know, I'm going to take a guess. Probably not, I mean, I think it's just like any other space, First, I mean, if you break down the racial dynamics of the first year hires that I remember, it was, the majority were white hires, and then there were a few people of color, But that's not the only thing. It doesn't matter who you have in there, it can still function as if it is a white-only space, because you're not even supposed to talk about it. Like things that we joke about on Comedy Central, on stand-up, like actually happen. Like I get mixed up for like 8 different Asian women. And it doesn't help that there's another Angela Chung who's Chinese and I'm Korean, but still it doesn't matter. I've been a company attorney for 12 years. Like little things like that, or like comments, like the court reporter takes all the notes and, making racial comments about your clients and things like that. Oh, she looks a little too ethnic. Making comments on, like there's little comments like that, So, I mean, it's not like any other space, it's just that maybe for my I chose what space I would be in my 20s, and then I decided to go to law school and then the county, and then it was like, yeah, welcome to the real world where everybody is anyways when you were like tucked away in this anti-racist organization, right, with all that kind of analysis. But the reality is, yeah, it is like that, and it's what's happening on, it's like comedy piece, ha 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 ha, funny, but it's really going on, So, yeah, I mean post-racial, affirmative action, whatever. I don't think there's no post-racial anything. We're just still dealing with it.
So is there a way to push back against that, though?
Well, I think that's the problem, is that you don't have a collective, it's a county massive machine of over 800 attorneys, clerical workers. Different people are unionized, like the secretary of staff is unionized with somebody else. The interpreters are unionized by AFSCME, the lawyers, they tried to get unionized, they're not unionized, there's a drama, but it's like, everybody has different political interests. I mean, that's true with any other space, but you don't get together for the county public defender's office to attack racism, You get together because it's like, I want to do trials, I want to fight. Everybody has a different reason why they're there, and unless you have a certain kind of leadership, like if people did things collectively, we can deal with so many trials in different ways, because the system only has so many resources, like the city attorney or the DA only has so many resources to go to trial on something. And if you understand those resources, and then you're the public defender, and you do a collective attack, you can dismiss a lot of cases somehow, or you can get rid of a lot of cases somehow. But no one's really doing that. If we all decided to take a strike because we don't like the fact that certain people aren't getting bail, or that immigrants are getting deported while awaiting just being arraigned, that could have an impact on the system. But it's not like people are going to do that, because it's not organized that way, it's not structured that way.
Can I speak to that? It does matter whether we're in post-209 or pre-209 world. My name's Kim Savo. I graduated from UCLA in 2002, and I'm a federal public defender here in Los Angeles. And why it matters is when you have fewer and fewer, in particular blacks, at the law school, you have fewer and fewer black public defenders. And at my office in particular, most of the black lawyers in my office are UCLA graduates pre-209. And it's, we can have a race-conscious hiring policy, which my office does. We have a hiring committee that is almost exclusively people of color. We orient ourselves towards trying our best to hire as many people of color and women as possible. But because you now have a smaller and smaller population of people of color in the law school, color blindness is becoming forced on, right? Workplaces, whether you want it to or not. So I think it's important just to make this link between what happens at the university level in terms of how that impacts the work environment, but not only how it impacts the work environment, but how it impacts my clients. So I just want to say that I do think it matters.
Kim's, Chris's, and David's comments all point us to the difference between UCLA as a pre-209 institution and UCLA as a post-209 institution. So what I'd like us to talk about is the difference in terms of the educational space as a workspace, right, for a lot of students, between a formally color-conscious institution and a formally colorblind institution. And Kim definitely, as someone who was here before 209, and then Citadel, who's here right now as well. If you guys could talk about your experiences and how you conceptualize the differences, and everyone else, of course, feel free to join in.
Do you want me to just keep talking since I just spoke?
Well, I guess what I kind of wanted to talk about was there's this assumption that, like UCLA as an institution is colorblind, but then, me being a part of groups like APILSA, of the Diversity Action Committee, of Shared JD, shows how race is still very much alive, and it's something that's at the forefront, but how at the same time that was part of a movement where we had to carve that out for ourselves. And groups like APILSA and BALSA, those came all before 209 was formally enacted. And I think that kind of shows how even before 209 the rhetoric around colorblindness still got infused in the institution, though it was a lot less striking because there was a lot more students of color at school. One of the things actually Rohini and I noticed when the alumni were walking in was how excited everyone got to see each other and how they were like hey, screaming each other's names across the room. And Rohini made a comment and she was like, that's what it was like before. That's how it was in Hollywood. They're not excited because they haven't seen each other in a while. That's they're falling back into how they used to interact with each other. And it's strikingly different now because I think in certain spaces I feel okay to be to get excited and to kind of just be louder and acknowledge, what I mean. But I think because colorblindness kind of subordinates people of color, maybe I don't know if that's what it is or if it's different dynamics. I guess I wanted to know from alum and from students now how they feel about how not specifically talking about race is how that affects how we're interacting with each other and that kind of thing. And then another thing I was thinking about was how it's weird that there's this dichotomy between how it's okay to, you can have very racially rich or conversations that are rich about race when it comes to diagnosing problems. So it's really easy to say it's a problem that we only have X amount of black or API or Latino students. But on the flip side, when it comes to prescription and what we should do, why does that all of a sudden switch into colorblindness? What is it? What's marking that shift? I don't know if anyone has any idea, but I'm curious about that.
I actually, on the first question that you asked, I do think that you feel in colorblind spaces, and it's one of those things that I, to be honest, even till now, I don't know quite how to articulate, but when I'm not surrounded by people who are race conscious, and who, they think they're race conscious, but they're not, right? And they'll say really racist things, but don't realize they're saying really racist things to me. I feel a serious lack of community. And I think that's one of the differences that I feel between, and that's why you hear me when I walked in here screaming, because I'm so excited, because I feel like I'm in my element. I'm with people who have my back. I'm with people who understand me and get me. Versus when I'm in a colorblind space, even though they're doing sort of quote unquote good work, I don't feel like they understand me by their very racist comments that they'll say to me. You know what I mean? So I think it's definitely a lack of community that you feel. But I'm still sort of in this process of figuring out even how to articulate it. And I think that the other thing that and actually I think Professor Robinson has spoken a little bit about this, you also feel like, as a person of color in a colorblind space, you kind of feel like when you make anything that you do is being examined, and it's not just being examined as Negwa Ibrahim doing this action, it's being examined as she does this, and then this is projected on everybody that is a part of her community. And so you constantly feel this overwhelming responsibility to prove yourself, you know, not just because you know that you're being perceived in a particular way because of your identity, and then that's sort of being projected on your entire community. So it's sort of dealing with all of that. It's just a lot. It's overwhelming sometimes.
I just had a question. I'm a single woman perspective student for CRS, and I was wondering, are there opportunities to build alliances and then call people to the carpet for their privilege or their ignorance in your workspace, and even in the university? I mean, but, you know, where you have that support to be able to voice that and hold that discussion.
There's a group that we're starting. It's actually right now, mostly UCLA CRS alumni. We're calling ourselves URGE.
Emerging Advocates for Racial Justice.
Emerging Advocates for Racial Justice. And there's a group, there's critical mass, you know, in the Bay Area, in Los Angeles. There's now a chapter that's meeting in Sacramento. And we're looking at developing a chapter in the Central Valley. And it's, like I said, it's mostly CRS alumni at this point and our friends. When our earlier iteration, we called ourselves the Young Advocate Mafia, because it was kind of like, you kind of get invited in by like who you know, because it's trust-based. It's trust-based. And it's specifically, the desire was that we needed the kind of camaraderie that we develop in law school, particularly as people of color who are doing CRS, that we kind of run to each other for alliances and inspiration and fun and relaxation and a shoulder to cry on, and then also advice. Like so the meetings that we have in LA are structured around like I call them like not your firm's case review. Like in a firm, you'll do case review when you're present on a project, and you'll get like feedback or input or advice. But in a lot of spaces, it can be a competitive process where especially like the senior litigators want to pick apart what you're doing, and it's not the safest place necessarily to communicate. But in these spaces, it's designed to be a safe space. So it's us, it's each other, and because we recognize that we're not. In our workplaces, we are often the only one or the youngest one or the most recent hire or the most vulnerable in a lot of different ways, and so we need that support from each other. So I can't speak to what the situation might be at your workplace, but there is definitely a growing awareness that we need to carve out these spaces for each other outside of the workplace.
Going back to Citadel's points earlier, this is a really important conversation for me, and I don't know how much I want to say, but I came in order to say some of this stuff, because I'm on the admissions committee, like the general admissions committee for the school, so not the CRS, not the public interest, the general one, which I did for conscious, obvious, CRS-oriented reasons. And interestingly enough, there's 4 of us on the committee, 3 people are CRS people, and the 4th is one of the few African-American students we have in 12 class.
And I think that that was a conscious decision on the part of the admissions committee, even though, of course, it's a completely perverse thing to try to operate admissions in a post-Prop 209 world. And so the way that we structure admissions here is the students get this pile of applicants. So there's three pools that all the applicants go into, and one is people who get accepted based on numbers alone, and the second is people who get rejected based on numbers alone, and then the third is this socioeconomic or hardship category. And those are the ones that go to the students. And then there's, we have a panel and we vote. And it is so bizarre, to be on this committee, because it is a playing God in so many ways. And from a CRS perspective, it's just a nightmare, because they're almost exclusively students of color or candidates of color. And there are only going to be 65 admitted from this total pile, and there are over 8,000 applications we've received this year alone. So you can imagine how many. We read about 40 applications a week. We're only supposed to admit about 8 of them. So you end up pitting the students of color against each other, right? And so, my question here is how, and I can't say too much, right, because I don't want to expose the admissions committee to liability, because we're not supposed to consider race, which is perverse. And it's supposed to be a colorblind application because ethnicity is removed. But of course, name will give it away. If you went to an HBCU, I can tell. Oftentimes, obviously a minority candidate is going to, involve that in a personal statement. So, do I make a case where I tend to make cases for students who have a history of social justice, race conscious activism, and who I feel like are going to participate in that on the campus. But then that's so perverse in a sense because, right, it's a double bind on those students, or a double burden on students. And so many students would have gotten, I don't hold white students accountable for that. We can't, right? So I get stuck where I don't know what kinds of rubric or what kind of criteria is the most ethical one to use as I'm sitting down looking at these candidates. And so I'm just really, and it's so important that you talk about, okay, well, the impact of this is that when somebody makes an inadvertently racist comment to me in a colorblind space, I feel a lack of a community. So I think, okay, well then students, clearly I should admit students who have a conscious social justice, racially conscious perspective, who are going to be able to communicate that, who are going to be more inclined to articulate when something inadvertently racist has been said to them, and who are going to be more inclined to work on student organizing, so that that is just a less frequent occurrence. But again, is that an ethical thing to expect, to demand that the students of color that we admit have that consciousness and that history of activism?
I think before I hit the point, I want to kind of unpack your question a little bit. I think you raised a lot of really interesting things, and I think thinking back to yesterday, and we were talking about, is colorblindness even possible? And some of the things that you're saying are, it's impossible. It's impossible. No. We're relying on these objective measures for, 2/3 of the class, right? So, or for the whole class, really, for the entire class. But are those objective measures even, something that we should be relying on in terms of LSAT, et cetera, et cetera? Are those the types of students? Is that the way we should be evaluating candidates for admission in the first place? So that's one of the things that we're challenging. Two is, what happens when the students get here? What type of environment what type of students are they admitting? What type of environment are they going to be confronting in terms of the so-called colorblind space? And I'm going to take your question, but I just wanted to throw in an anecdote. I'm sure I was one of those students who folks thought, you can come in and be a CRS student and really challenge the environment. I was one of 3 black folks in my class, 3 black women. And I was called Shauna and Nadine more times than I can count. And anytime Shauna and Nadine didn't come to class, I felt like Linda Brown. I felt like another name. I felt like I was integrated in the classroom. So I felt like I had 4 names in addition, 3 other names in addition to my own. And it was difficult because I felt like colorblindness pervaded the space so much that anytime I wanted to, as a CRS student or as a student that was race conscious, intervene in a discussion in criminal law, for example, or constitutional law, where we're talking about rudder, maybe, talking about race, I don't know. Trying to intervene in that discussion. Sort of the colorblind, philosophy of the colorblind, legal structure, 209, sort of served, I thought, to silence people and to tamp down discussion, even of professors who I read their writing. who, might otherwise be liberal and be inclined to discuss race. Clearly not CRT classes, but professors who you maybe could engage in, and they were silenced. So I think the colorblind space is really deep. And so I'm hoping folks can talk about not only their experiences in terms of, not only the admission side, but the experience side, and then how do we intervene. We have Kendra that's going to talk about this. Hopefully Kim can talk about this from her perspective of being here, during the initial or pre-CRS 209, that sort of space, and Kendra being here and being a student activist, trying to organize within the space to give folks voice. How did 209 and this sort of colorblind regime interact and influence your experiences on sort of both the classroom level and then on the activist level? So Nina, if you have any comments.
I wanted to go back to what you said. I feel like what you guys were saying about how to think things have changed, it's totally true. But I don't think it's a bad thing, because what happened with Sandra last year was horrible, but it was the first victory. It was our first victory against Sandra.
Can I explain it? Because I don't think everyone knows.
Does somebody else want to explain this?
Oh, God. Quickly, there's a professor here at UCLA who has what's called mismatch hypothesis theory, or mismatch hypothesis, and what he explores in his work is the idea that if you don't have the numbers to be admitted into a higher education institution right off the bat, and if you are admitted through some other program, some equal opportunity program or something similar, then you're being set up for failure because you are not prepared to be at such an education, and you will not be prepared to do well in the exams, and in the end, at law school, the end result is you won't be prepared to pass the bar. So he believes that instead of raising the bar for these sorts of applicants, that instead they should be being funneled to second-tier law schools and higher education institutions, because that's where they belong. This professor here at UCLA has done this work since 2005 or maybe more. He's engaged in a couple of different strategies in order to move this work forward, and he always, some of the stuff that he does ends up getting responses from student activists who try to organize against the stuff he's doing. So last year, the victory that Nina is talking about is Sandra went to the California bar and asked for a series of data points about bar applicants here in California. And the California bar said, no, we're not willing to share that information with you. We have all these privacy concerns and we're not going to give it to you for your research. And so that's the victory that Nina is talking about, because we organized a lot to show up to the hearing, and a couple of people here testified, not the hearing, the meeting, the board meeting, whatever it was, and they denied him. He's actually moving forward in the court systems right now, so we'll see if we continue with our victory. But the one that Nina is speaking about was the first time that we had won something against.
So I think that was a big deal. The movement around Share JD, even if it feels like we're not doing anything right, the administration is very aware of Share JD.
And what is Share JD?
Students helping to assure racial equity, justice, and diversity. It's basically the student activist organization on campus, but most of our work is around racial justice. All of our work is around racial justice issues. And then there's the Palestine issue, like the movement around Law Students for Justice in Palestine. That we have been, over the 4 years or 3 years that we've been around, we are increasingly getting stronger reactions from the administration at increasing rates. Like we are getting more and more reaction from the administration on a monthly basis or whatever. So my point is that as we become stronger, they're going to become much worse. And Schill's going up for renewal, our Dean Schill's going up for renewal. I think he already got it. So he's going to be in his second, it's like the presidency, right? The presidency has the opportunity to do much more when he's not going up for re-election. Schill's going to do much more when he's not going, because it's going to be his final term. So things are going to get worse as we get stronger. And I think at some point there's going to be a turning point where we become so strong that, I hope. Oh, and also the alumni-student collaboration, I think, is really threatening to the administration. So I think we're in a rough spot right now, but I think it's going to get a lot better because of all the organizing that we've done over the last 3, 4, or 5 years.
I agree. I think that the change has been positive in many ways, but I think the thing that
that I find really difficult, and I want to engage here, is listening to Andrea talk about the type of community that existed before we got here, that I think as 3Ls we saw kind of the end of, and that function as a community that can be pulled together now as alum to like provide a space outside of a workspace that allows for kind of support, but also intervening into the workplace and all these different things, that I don't think that community necessarily exists on campus anymore. And I think that, like, while we're moving forward in terms of our agenda as, like, you know, politically defined, that I don't think that the sense of community and the vibrancy of community exists anymore. And I want to know what that's about. And I think that a lot of it is that within our separated communities of color, like, as, you know, defined in all these arbitrary ways, have been able to develop kind of within themselves. I feel like there's been a disconnect in building like a solid movement for the sake of solidarity that can actually continue this project, the agenda, but both the project of building community, you know. And the point of building community is, once we get out of school, to be able to continue to rely on each other, you know. And I want to be able to engage what the experiences of the alum looked like before and what the campus looks like now, and how we can start to bring these 2 points together.
Well, we want to talk about this for a little bit longer, and we're going to move on to our next point. But we'll take a few more comments. But I know, Kim, you had some things to say about what it was like.
I give you a little historical memory, and also I hope maybe a little hope. And maybe, Tia, you can clarify, or one of the other factors, I can't remember, but my recollection, I do not remember students being on the admissions committee during my time here. Do you know if that's, am I wrong, or is that a change since my days?
You know, there's
an advisory capacity.
Yeah, but I'm saying I don't have any recollection of that being true when I was a student. I don't. I was the class of 2002. I chose UCLA because when I applied in 98, 99, at that time there was no single ethnic majority in the UCLA student population, and that was something that the institution was using to recruit people, was that fact. When I got here, after the passage of 209, there were 2 black women in my class, and they were the only black students in my class. And there was also an extremely reduced Latino population in particular. If my numbers are still good, I think we had 12 Latinos in my class. And so, you know, a group of us started agitating to try and put pressure on the institution to change how we admitted people to the school. And what I want to share with you is, one, CRS exists in large part because of the activism of people during my time here, and it was designed in part to create another means of attracting people and providing an alternative admissions process to bring more students of color here. And the fact of this symposium, the fact of this conversation in this room, for me is such an extraordinary change, and it's really such a pleasure. And I want you to know that things, although always in need of change and growth and improvement, you can't imagine really how much better this is. It was, people have been talking about this idea that the alumni had some sense of community. That may have been true for Chris, but it sure shit wasn't true when I was here. It was an extraordinarily hostile, very painful environment. I don't think the word Palestine was spoken by a single person other than myself when I was a law student here. And so just the concept that there's even a group of students talking about Palestine in law school is, like a real bomb to me. So the things that don't sound to me like they have changed and that still bother me are the fact that the law school persists in using certain admissions criteria that it considers to be objective, that are a mask for, in particular, I think, class and race bias. And that includes the presumptive admit in terms of scores, and also the weighting process that is given to what undergraduate institution you went to. And one of the things that remains an incredible frustration to me is that 209 does not require this institution to have that kind of weighting process, and this 209 does not require this institution to have scores that create a presumptive admission. That's a choice that the institution makes, and in particular, I think, and I'm sure people, the scores is a whole conversation in itself, and why the test is biased and et cetera, but the undergraduate weighting factor is the thing I think that really bothers me the most, because it is so crazy that if you go to CSULA and have a 4.0, you don't have the same chance of getting into this institution as if you go to an institution that gets a higher weight in the admissions process. And so that hasn't changed despite the amount of activism that my group was involved in, and I think that's something that still needs to be really pushed. But I also don't think the students were involved at this level when I was a student, and the fact that there is a group of students who actually get to review applications is also a kind of progress that I'm really glad to hear about. I don't know if there are other particular things that people are interested in to the extent that I can provide some historical memory. I'm happy to, but it's gotten somewhat better, and so it's not back to where it was when Chris was here, and I don't think it can be, so long as there can't be a truly race-conscious admissions process.
Yeah.
It's better than when I was here.
For perspective, pre-209, the student associations like BALSA were given the opportunity to review applications and advocate on behalf of individual candidates. And as she said, my class, there was 30-something black students, and the total in the school was 90.
That's so sad that that's a lot too.
Yeah. And then you had 209, and look, the people who control the institution are lawyers who benefited from. That's why they're here. They benefited from the process that almost all law schools in the country use, and we had close to knockdown, drag-out fights as an alumni coming back and trying to influence what that process was going to look like. And because their basic mindset was, sorry, we loved the way it was, but this law is passed and we're just now going to have to go to LSAT scores and we'll do some kind of socioeconomic thing and that'll get a few people in. And that's kind of the end of the conversation. And the dean at the time yelled at me in a meeting and said, you're going to get us sued by even suggesting the things that you're trying to bring up.
Like Professor Crenshaw said, 209 made us do it as sort of the subtext. And I think kind of the comments that have been said sort of suggest that colorblindness is masking multiple sort of racial biases and sort of race consciousness that negatively impacts people of color. So in the admissions context, these so-called objective criteria are really masking sort of racial preferences for white folks or for privileged folks. And then in the classroom, you have this so-called colorblindness, which is really masking the hostility that exists within the classroom. And really, I think, it really disempowers students in terms of being able to articulate and push back within that space. And just before we move on, I wanted Kendra to talk about how students push back within that space, just very briefly, and then we'll move on and talk about some of the comments that were raised in terms of the workplace. So, Kendra, if you want to go.
I guess the thing that I wanted to share, given the tenor of the conversation, is one, I think part of our job as CRS students is to just buck up. You know, like, you have to do it. That's why we're here. So we came to Professor Harris our first year, and we were like, we don't like sitting in torts and having to have conversations about intentional infliction of emotional distress and how the N-word, is not a viable claim. And she was like, yeah. That's actually why you're here. And the program that you're in, which is all about creating an oppositional space, like that's your job. And hopefully, if you're lucky, you'll get out into the world and litigate or produce scholarship. And there it's really hard too. So the whole idea that, I don't know. I know that it's hard. It's hard for all of us when we're here, but that's part of your job, being students here, and that we are so lucky to have this space with a resource like CRS because other civil rights litigators didn't have that. And the idea that the law school doesn't owe us anything to create a community for us, that is not the purpose. In fact, the purpose is the opposite. So when you're here, that's part of your job, is to create that community and also to dedicate yourself to producing scholarship that challenges that. And I think I didn't get the scholar, like I came and I was focused on the student organizing piece, and I didn't really put any energy into the scholarship part, I think, until my last year when I was able to work with Professor Harris on a paper around putting what we were experiencing with Sander into a legal context, into a hostile environment context, and just trying to, get your footing as a future practitioner. And I think that is also important, and one thing that students should use CRS for, not just that it's a community to talk about how effed up everything is at the law school. Like, we all know that conversation, it needs to keep happening, but we also have to produce work, and we also have to commit ourselves to going out into the world and doing work. So if you came into school with a commitment to doing racial justice work, try as hard as you can to stick with that commitment so that when you're coming out, you're a litigator for racial justice. And you're not, all of us, hopefully, are not going into environments where it's not possible to do race-conscious work. We have to choose also to go into environments where we can do that work and where we can move those kind of cases along. Otherwise, we're complaining that the environments don't exist, but we're not committing ourselves to working in those environments and to forcing those kind of cases forward. And so, not that the work environments are perfect also, but I think the fact that some of us are able to do school desegregation work where we are challenging Proposition 209 and the whole idea that race consciousness is not a racial preference, or we're doing voting rights work like NIP is doing, or we're doing police misconduct work. Like that is CRS is supposed to produce people to do that kind of work in the real world, and the struggles that you face here are exactly what you're going to face when you go into a courtroom or get in front of a jury that really doesn't know what the hell you're talking about, or you're operating within these conservative legal frameworks. And so that's my long, drawn-out way of saying, you're here, you're in this program for a reason, you just have to commit yourself to doing the work and building the community. And it's not like we were building that community with 150 people who were here. We were building it with like 8 or 10 or 15, so it's entirely possible. And from what I know, CRS has a much larger community now than we've ever had. So I think it's really important to take advantage of that.
I think a lot of what students are wondering in the CRS program is, despite our use of the CRS community as an organization or a space around which to rally and push changes, like push against Sanders, increase awareness about Palestine and Gaza. To what extent does that change, especially when you go into a legal system that is in a lot of ways formally colorblind, right, or doesn't want to recognize color? Because to what extent are a lot of the things we're learning just intellectual exercises, I think is a big fear on the part of a lot of CRS students, right? And we learn about how responsibility to protect and humanitarian intervention might be really racist, but when I go out and I want to be a refugee lawyer or an asylum lawyer, I'm arguing, oh, look how awful it is in other countries, look how better it is here. I mean, if practitioners can really talk about that, maybe students can share their concerns that
Actually, I do want to talk a little bit about that, because I know that a lot of times we think that coming out of the CRS program that what we're being trained to do is produce scholarship. And I actually think a lot of what we're learning is incredibly important as a practitioner. And I'll give sort of a very specific example. Because what we're doing in CRS is we're learning about the complexities around race and the complexities around discrimination, right? Because it's not as overt as it once was, and you have to be able to see those subtleties, I think, sometimes to effectively litigate a case. And it's also I think that, and that's where, I know for me, working in sort of a colorblind space, but coming from CR's background, I can see certain things that people who've been doing civil rights litigation are not seeing, right? And a very specific example of that is how race and discrimination plays out in the context of cases that are not directly dealing with a racial discrimination claim, right? So and this is no joke, we have had jurors that will find liability on the part of a corporation, right? But will reward damages, very low damages, because of the race and ethnicity of our client. And the difference between someone who's race conscious and someone who's colorblind is that they see that race is going to play out in this case because of the race and ethnicity of their client, right? And so they are thinking about how to deal with that in terms of their litigation strategies. And that's something that came up in a recent case that we did, and nobody sort of thought about including certain comments in their closing and opening statements with regards to race to try to deal with that. And so again, I think that what we are learning in CRS is incredibly significant and useful as a practitioner. And I think the other thing, and this is what I'm still sort of grappling with, and this is sort of my last point on that, is figuring out, there's such an amazing intellectual engagement around race when you're in CRS. When you go into the workplace, it's very different because the law is engaging race in a very traditional way, and so your colleagues are engaging race in a very traditional way. And what happens is you don't sort of try to push the boundaries or try to be creative in terms of your litigation to expand anti-discrimination laws. And so I think that's something that can be very useful in terms of what we learn in CRS, to trying to create new precedent around anti-discrimination laws based on our intellectual engagement around race within CRS. Because in these colorblind spaces, these civil rights litigators who are not doing this type of intellectual engagement around race are not doing that. And so that's where I think it is incredibly useful in the litigation context.
I want to share an experience that I had with Chris. I actually worked with Chris after law school, so I've known Chris for a long time. And when I was first public defender in my first year, I one day got, I think it was 14 clients who were all black, all disabled, either physically or mentally. They were all charged with a form of Social Security fraud. And they were all arrested the same way the police would arrest a client of mine who had been charged with, I don't know, selling drugs, as an example. 6, 7, 8 agents, guns drawn, showing up at people's houses at the crack of dawn, and arresting them to bring them to court to face what in the federal court system it has got to be the least important, least significant, least dangerous crime conceivable. And
you should explain. It was for cashing a check that the government sent them by mistake, and not refunding the money.
And So the thing that I think is important here is that it is not that my colleagues are blind to race, but that we get so used as an institution to not prioritizing it. And I think that I had the benefit of most recently really thinking about and writing about race in a very conscious way so that I could bring to my boss's attention that, wait, white people charged with this crime they're not getting arrested. They're not getting arrested. These people are going to get a summons in the mail. And so I reached out to Chris because at that time Chris was the president of the Langston Bar Association, and they sent a letter to the then U.S. Attorney and got an extraordinary response, which was a written apology from the U.S. Attorney's office for what happened. And the reason I bring it up is because one, I think that it's an example of how race plays out in allegedly colorblind spaces all the time, that you have to bring it to the attention of the institution over and over again, because that's hardly the last time I've ever had to do that. But also the fact that we have created a community so that I can pick up the phone and I can call Chris and I can say, we have a problem and we need to do something about it. And that, what Kendra is saying and what you're saying of urge, whatever this organization is that you guys are working on, is that you take what we've learned here and you go out into the world and you put it in the front of what you do. And when other people in your institution aren't backing you, you pick up the phone and you call the other people that you know from the CRS community and say, I need your help. So I offer that as an example of where I really feel like the education together with the community helped me make some positive outcome in my work.
I think we are coming close to, where this discussion time is supposed to end. And if y'all will humor me, I think we have a break after this. I'm not sure.
Starts at 10:30.
Starts at 10:30. So if you guys are okay, we can keep talking for a little while longer, if that's okay with folks. Is that okay? So we'll take some more comments. I saw Claudia's hand, Andrea, and then we'll take your comments. Oh, and Nick.
I just have two comments to make about the transition from UCLA to whatever your workplace is going to be, and it sort of connects something that Kendra and Negwa said. So 2 points I want to make. One, when Kendra said, this is the work, like you just got to buck up, there's nothing that can be said that's more true than that, right? You came to this school with a certain set of commitments. Of course, they're going to be challenged your entire 3 years here, and you're going to learn to hone the arguments that you already knew coming in, but you have new language to address those issues. And once you leave here, you're going to continue to challenge them for the rest of your life. Nothing is going to be changing so soon that this work is not going to be needed, probably till your mortality. Not to be morbid. So, and when you leave UCLA and you enter the workforce, you're going to work at spaces that are more like CRS. Like I work at the Equal Justice Society, an explicitly racial justice organization where we talk about articles like the Trojan Horse and engage CRS scholarship in the research work that we're doing. And you're going to work at places that are more like your more general law classes, like your tort classes and your contracts classes, right? You're going to work at those spaces that are more colorblind, where people discuss things that are supposed to be objective, but you know because of your CRS training that it's incredibly subjective, right? So it's going to be the same but different. And what you are getting here at CRS is an incredible set of tools that gives you sort of the maximum potential to engage these issues once you graduate. And can I just tell you that as a student, I knew that. I had seen that sort of by engaging other students from other law schools, but now as a practitioner, I can see it more than ever. We have people that come to EJS, people that we work with that did not go through CRS as trained as students, and their analysis is
so different, and so many times we have to catch them up to speed to get where we are. And I know that that's true for people working in other organizations. So you really have to maximize this opportunity that you're being given here at CRS. Everything that you learn is going to be used once you graduate, if you so choose. Now, you can decide to just leave everything at the door when you walk in. People walk into the doors of this law school forgetting their organizing skills, forgetting their commitments to social justice, forgetting all the things that they learned about the world before they walk in, and they walk into the space thinking, oh, it's a brand new space, I'm going to just like start from scratch. You can do that, and you're certainly going to lose, right? You're going to lose all sorts of opportunities that you have. And once you leave UCLA, same thing. No matter where you work, CRS should be in your pocket every single second. It's always going to be relevant, no matter what you do. Even if you're doing wills and trusts, CRS is going to be relevant. So please don't forget that. It's always going to be challenged, but it's always going to be useful.
So, Andrew was next. I just want to, for those that are here, this is my, third year out, and every year, as an alumni, I have heard similar complaints from the students that are here that we experienced when we were here. So for over the course of 6 years, we hear the same themes over and over again about classroom experiences, admission stuff, community building or the lack thereof, hostility in the law school, backlash to organizing efforts. So what I try to say is reach out to alumni, those of you that are here, and tell the next incoming class that they can rely on you, rely on us, because at some point we will hopefully develop enough cohesion between current students and alumni that the institution can stop relying on the fact that there's turnover, right? Because that's what they rely on. We could do a lot more change in this institution if we had more cohesion. So I really encourage you to, especially for those alumni that come to these things, reach out to us. We're coming here because we're interested and we're so committed. I have cards to give. Everybody has cards to give. Give us a call, send us an email, ask us to come, and we will. I think the person that had a question over here just stepped out, so we'll go to Nick.
I think that I just wanted to build on something that Nagwa said a little while back, and that's about the use of CRS. And I think that one of the ways that I feel that I've been, at least personally, been able to use my CRS training is that CRS, it does two things. One, it just doesn't teach us that colorblindness exists in the law. It teaches us it's an ideology within the law that both has hegemonic sway but is not completely ensconced within the law. And so finding the ways in which, and understanding that there's a tendency within the law to push towards colorblindness, and understand that the challenges that we'll face as litigators and lawyers will be increasingly subject to critique through colorblindness. I know that, Kim mentioned the use of test scores and choosing which weighting institutions. Well, right now, in the current Supreme Court jurisprudence, we're seeing that the choice to abandon tests that have a racially discriminatory impact because institutions realize they have a racially discriminatory impact is now being challenged as unconstitutional race consciousness. So, the fact that CRS provides us this tool to think about colorblindness is something that we can think about as students, both in terms of articles about how to contest these new uses of colorblindness, but also how, as litigators, we may respond to them. And the second thing, and the thing that I think I find most useful, is that CRS is part of a story of how legal theories contest each other, both within the academy and within the law. And what that does for me is let me know that it's okay to raise or to advance theories that may not be currently enjoyed. Think about the ways in which to reframe race. And I think that's something that it was Claudia that said about people aren't thinking necessarily, or someone said about old civil rights litigators may not maybe stuck in their ways, not be thinking in these ways. And I think that's really what we bring to the table is offering new theories or the courage to, even drop a couple footnotes somewhere that relate to a disavowed line of cases and attempt to resurrect it. And I found that to be very, very helpful.
Yeah, just to build on that point, I think it's really true that obviously I think it was talked about in the first part of our discussion, the legal culture is conservative, right? And it's pushing this colorblind line. And I think from my experience, I did a clerkship and now I'm working at the Lawyers Committee with Kendra. There was a tendency because of this sort of colorblind ideology within the law to, like Nugget was saying, to minimize race because it's not technically relevant to the discussion, right? So our legal jurisprudence around particular issues now said that race is not part of that discussion. So in the Fourth Amendment context, we don't, or in the Sixth Amendment context of criminal law, we might not talk about race because the Supreme Court has said it doesn't matter. So now we're being trained in a way practically when we're litigating or we're going about our business or we're discussing cases that the race of the defendant might not even get a mention. I had the experience when we would be writing, memos and opinions that the race of the defendant was all over the place. It was all over the place in terms of why the person was stopped, why the person was searched, why the person was arrested, why the person was convicted, why the person was sentenced to 10,000 years. It was all over the place. We saw this yesterday in terms of, stereotypicality. We have all kinds of evidence that race is significant in terms of who was targeted, arrested, convicted, and sentenced. But it's not technically relevant to the legal question. And so we don't even mention the race of the defendant. You know what I mean? So I think that coming out of a CRS perspective and just seeing how colorblindness is so pervasive in terms of the way we even think and approach things, it becomes, for many people, even when they come out of a space where they may have been exposed to things like critical race theory, it becomes so automatic because it's not technically or practically relevant. So that we become lazy in a way, and we start to fall back on the colorblind arguments. We're not putting the footnotes. We're not, for example, in my chambers, I had a really good judge, and he would be willing to write concurring opinions to say, this is ridiculous. Race is all over the place. Race is all over the place. But how can we get folks to challenge people like in EJS to say, we need to have a dissenting opinions project. Folks need to write dissenting opinions. Folks need to write concurring opinions so we can get this stuff in the case law. Folks need to be citing to, CRS and CRT articles to suggest how we can grow, the case law around this, how we can push back against colorblindness, even if it's in a concurring opinion where it doesn't technically, solve the issue, but we can influence that in terms of the briefs that we're writing. But if we don't give the courts and the folks who are making the decisions the ammunition to do it, they won't. So, I think just folks being really creative and not falling back on the conservative colorblind line because it's easy and we know the case law around it and we don't have to be as creative. I think we should try to resist that. Kendra, you have a question and then we'll close.
No, it's not a question. I just wanted to share a little glimmer of hope since I just experienced it. We were working on an employment discrimination case and it was a race case. And our client was a black man. We had a jury that was all white and Asian. We had to piece together a whole bunch of circumstantial evidence of discrimination, old-ass statements from the mid-'90s and late '90s, and we were like, oh my, this is never going to happen. And our lead attorney, was referencing or wanted to reference Medgar Evers and all these other things in our closing arguments, and we were like, oh my God, we are not going to make it. And we won. And he won like a almost $700,000 jury verdict. And so the case is still win, is my point. We can still win, and it's really important for us to be out there litigating these cases. So even if it seems doom and gloom while we're here, it's important that we're out there fighting for these clients.
Why do you think you won with all the stale evidence and all of
I think that even though the evidence of the racial slurs was stale, we had good comparators, meaning, we were able to point to some white folks who had done the exact same thing, who hadn't been disciplined, who hadn't been terminated. That combined with the head honcho guy saying awful things, and there being white people to testify to those things, and not just being our client's word against his. So piecing all those things together, they believed us, and I was like, wow. I had prepared to lose.
there any more questions or comments?
I was just going to say, I mean, I think one of the things that post-209 the students learn is it's not necessarily practical from a, how am I going to use this in a legal argument, but they learn that being a person of color in the world is a full-time job on top of your job. And I kind of go back and forth as to whether it's a good thing that you have to learn that at 22. But you know, the reality is you're going to, at some point, you're going to walk out the door and have to figure that out. And people react to it differently. Sometimes people are like, I don't want that extra full-time job, and they just kind of go and do their thing. So, you know, I waffle back and forth because you know, it's tough. I got a lot of drinking I got to do. I got other stuff I'm trying to kind of fit in, but you know, it is. I'll just share the mistaken identity. The best one I ever had, which is I shared an elevator in McCutcheon. We shared with Munger Tolls. Someone actually from Munger Tolls, which I did not work for, gave me an assignment. You know, it was a routine thing because there was another light-skinned brother at Munger. It's a routine thing that they would confuse me for this brother, but somebody actually was like, you know, could you look up? And I was like, no. And I just, you know, it's like, I was torn. Do I call this brother and tell him he's about to get a bad review because he's not doing the work? So it just, you know, and I was just like, you know, at that point it happened to me so often, I was just like, yeah, I'll look into that. But, you know, that's a nice way to start out the day. That's like your whole little extra job that you had to do. Quite literally, I was working at 2 firms.
So I see Saul's here, so I think that means we need to go. But just thank everybody. Thank you.